Good morning, everyone, or possibly good afternoon or good evening, depending where in the world you are. Obviously, the beauty of these online webinars, you could be absolutely everywhere. But regardless of your time zone, thank you very much for joining us today. So we've got our slightly viscerally named webinar, Cockroaches in Plain Sight, the Emerging Risks of Private Credit, about to kick off, where we'll explore the sort of emerging integrity risks in the sector and how firms can really strengthen diligence before those risks become real exposure. So as I'm sure you're aware, the market continues to evolve. It's becoming increasingly important not only to identify financial risk, but also to really understand who you are lending to, who they're connected with, and how those risks can really change over the life of a loan. So we've got an incredible panel with us today, and they're going to share some regulatory context around this issue, what happens when things go wrong, and then some of the practical insights into the controls and processes that firms can put in place to really stay ahead of those sort of regulatory and reputational challenges. I'm Olivia Dakey, the research principal at Themis, so I will be moderating this session. I can't profess to be a private credit expert myself, but I'm surrounded by absolute experts on this webinar who I'm sure will teach me as much as they will teach you. So first of all, we have Emily Shepherd, who is a COO and an independent advisor with extensive senior leadership experience across financial services. Most recently, she was the Chief Operating Officer at the FCA, the Financial Conduct Authority, where she oversaw strategy, operations, technology, communications and finances. And prior to that, she held COO and director level roles at Bank of New York Mellon and Aegon UK. She's also been recognised in the top 100 women in finance in Europe and served on the UK's Women in Finance Executive Task Force. So we're very lucky to have Emily with us today. But we are no less lucky to have Dan Hemming with us, who is a partner in the London Commercial Disputes Group of the international law firm RPC, where he specialises in financial services litigation, acting for a range of clients, including private capital, European banks, investors and borrowers. So he's extremely well placed to talk to us about what can go wrong in this sector, possibly to be the voice of doom and gloom on our panel, because we do always need to have one. And then last but not least, we have Jake Astor, Themis' very own Managing Director for UK and Europe, and he will be telling us what we can actually do about it. So that voice of hope at the end to end the call. So at Themis, Jake leads growth, strategy and senior client relationships, and he has spent much of his career in private equity, including as a partner at Casio Investments in Hong Kong. And then more recently, he advised on strategy, capital raising and M&A at J. Goodwin & Co. So that background really does give Jake a direct line of sight into how lenders, sponsors and investors actually make diligence and risk decisions, and where integrity risk does tend to slip through. So for the sake of kind of thematic continuity, I'm going to take each panellist in turn rather than dotting about between them. So I'm going to start off with Emily to kind of scene set a little bit and talk about that regulatory context. Throughout the webinar, you should see a Q&A button at the top. You can submit some questions as they come up for you. And then at the end, I can feed those through to the appropriate panelists. You won't be able to see them, but I will be able to see them. And I will remind you again about that at the end. So Emily, if we do start off with you, why is it that private credit is now under such regulatory scrutiny?
So I think the first thing to say is private credit is an incredibly important part of the market. It creates a pool of funding for small businesses, medium-sized businesses, and high growth businesses that otherwise might not be available. So I wouldn't want everyone to think that all private credit is evil or cockroaches or anything like that. It is far, far from that. But the way that the regulator thinks about it is basically from the regulator's fundamentals. The regulator is there for three reasons. It's the good functioning of the market, it's protecting consumers, and it's to ensure healthy competition as well. So if we sort of go through those and think about what it means for private credit, one of the challenges it has is how opaque the market is. The regulator doesn't see what's going on. For the Financial Conduct Authority, even though it's based on conduct rather than the PRA, which is based on prudential regulation, with 42,000 firms, of which only a couple of thousand are regulated by the PRA or Bank of England, the FCA is the largest prudential regulator we have in the UK. So it is thinking about, how long is that funding there for? What happens if, and what happens if the firm goes wrong? So one of the challenges it has is on that prudential lens, how the valuation's done, who has seniority over that debt. And that can have implications onto the consumer side as well. Recently, a lot of private equity has gone into platforms which have consumers at the end. So that is possibly an area of some sensitivity. The second piece with a good functioning of the markets is really about doing the right thing. So doing the right thing can mean getting rid of incompetence, or it can mean criminal activity. So criminal activity is where we sort of walk into AML and KYC. So anti-money laundering is one of those things that I think London has had a poor reputation for previously, and we are fighting towards it. Now, fighting towards a cleaner market. Anti-money laundering as well is going to be consolidated under the Financial Conduct Authority as the primary regulator in the next, I think it's about 18 months now. So that was a piece that was passed in September last year. So for lots of those reasons, that is why the FCA at this point in time is particularly interested in private credit.
Thank you, Emily. And so how can, because I know a common complaint that I hear, and this is not just from sort of the private credit sector, but across the board really, is how firms can really kind of balance growth with stronger financial crime controls, because there's often a bit of a trade-off here. So maybe you could speak a little bit to that for us.
I mean, yes, there's always a trade-off between how much are you going to invest in growth and invest in your clients and your product versus keeping those fundamental controls in check. And it is important to keep those fundamental controls in check. So if things go wrong, if the regulator were to come in and say, you're not doing AML properly, then the potential impact of that is you could have a simple investigation, which will take time and be a distraction. You could have a rule put on you where you can stop doing business. You can have a Section 166, which is quite a distraction. There are lots of things that can happen. For all of these reasons, it is really important to keep on top of just basic compliance. And AML really is basic compliance. So don't gild the lily and go over the top. But you just need to make sure that you are as clean as you can be. Anyone who doesn't have any suspicious activity reporting that says, I know my clients, they're fine, that to a regulator is a bit of a red flag. So absolutely no suspicious activity reports. You might get a knock on your door and say, really?
They're not looking hard enough would be the answer to that. So to try and just end on a slightly practical note, because that's obviously why people are here, what should firms be doing now to prepare for increasing regulatory expectations that you've talked about?
So for private credit firms, I think one of the things I do is talk to the regulator. So when the regulator is looking at creating any new regulation, one of the things it will do is send out communications. It will hold round tables. It will get ideas. The regulator is there really to try and figure out what the current best practice is in the market. And I know it's a very amorphous thing, best practice. But what is the best practice in that market? What do the private credit firms do now to make sure that they are in check? And try and replicate that and hold that as the standard. The regulator is there, is paid for by firms like private equity or investment. It is paid for by those firms to protect that market, and therefore you should be using them and talking to them. So that's the first thing I'd do. The second thing is really get to grips with AI. I know it sounds very bandwagony, but there are lots of things that you can do, particularly around reporting, which make things far, far simpler. Even Copilot, which most people have got, even Copilot can find things on your system, can help you create those policies, can help everybody understand and learn what is needed. And I do think AML will change over the next 2 to 5 years quite dramatically. I know that there are some quite progressive ideas in the regulator around that.
Okay, amazing. Maybe we can come back to some of those in the Q&A. So Dan, if we move on from the sort of scene setting and context and onto your slightly doom and gloom section. If you could maybe lay out for us first, before we kind of funnel in a bit more narrowly, what the current state of private credit litigation is in England and what sort of claims that the sector needs to be concerned about.
Yeah, thanks, Olivia, and thanks to you and Themis for inviting me along. Thanks, Les, for the setup. This is going to be doom-laden and miserable because I'm going to be extremely balanced, even though I'm a litigator. I think it's fair to acknowledge that, particularly in England and in Europe, it's early days for private credit litigation, but lots of people, including me, I'm afraid, are predicting an increase in private credit disputes in England over the next 12 months or so. We are already seeing quite a lot of litigation in the US, I think partly because the market's bigger and more mature, and there's been more of a push in the US into retail already, which I think is still in its earlier stages in England. It's also somewhat trite, but it's losses that lead to litigation. No one really cares how they've sold an investment when it's performing. However, and I think to misquote Warren Buffett a bit, in private credit, it's probably fair to say that even though the tide is still just about in, you can spot a few naked swimmers on the surface already, possibly some cockroaches too. The first category of claim I wanted to mention is investor claims. So as I said, if and when investors lose money, they're going to scrutinise what they bought, and that's usually going to be in more detail than they did at the time they bought it, and often with the benefit of hindsight. So potential targets here, we're talking about fund advisors and sponsors, also wealth managers and intermediaries who gave advice or recommendations on these investments. So here we're mostly talking about what would commonly be called mis-selling claims, which in a sense is nothing new. So these are the same sorts of claims we've seen in relation to other types of investment and financial product, especially following the 7-8 financial crisis. So these are generally claims focusing on representations made as part of a selling process and suitability. And it's fair to acknowledge, I think, that the risks will increase with the push into retail. I think because first, less sophisticated investors place greater reliance on what they're told, and also because individual investors will have a direct remedy for losses caused by regulatory breaches, which Emily's already touched on. The likely areas of focus in these claims, so I think this will be both for mis-selling and other potential types of claim, will include underwriting, because where loans don't perform, statements and disclosures made about origination, due diligence, and underwriting processes are going to be key, and they're going to be scrutinised. I think in turn that links to valuations, where there are some pretty fundamental challenges around opacity and subjectivity. So the questions here will be things like what do the fund materials say about how valuations will be carried out? What sources will be used, and how does that all compare with the reality of what is in fact done? We also have redemptions and liquidity. So again, have the redemption mechanics been adequately disclosed? And more fundamentally, is an investment with limited liquidity suitable for people who it was sold to? And lastly, just briefly, there's also conflicts of interest, I think particularly in relation to the links between fees and valuations, and also in the context of secondary deals and continuation funds, which I think is a growing issue in private credit and private equity as well. A second category I just wanted to mention quickly is lender-borrower disputes. So that can be in the context of the private lending itself, but also bank lending to funds when there's some gearing in the structure. Again, I think the types of dispute are going to be quite familiar. So things like breaches of covenant, distress situations with related issues around enforcement of security and restructuring, and also fraud, which I want to come back to in the context of MFS in a moment.
Yeah, I think that's a case many people will be familiar with and want to hear a little bit more about. So you mentioned before that we're already seeing litigation around private credit in the US. What are the lessons that we can kind of take from there, and what sort of claims are they seeing over there?
Yeah, so I think there are really three buckets of claims in the US that are worth mentioning. The first relates to first brands, which I'm sure people are aware of, which is probably Jamie Dimon's primary Cockroach from the title of this session, and Tricolour as well. There's a lot of litigation around those companies, but these claims are pretty specific to the US and the facts of those cases. But we are now seeing something comparable with MFS, which, as I say, I'll come back to. The second bucket is Securities Exchange Act claims. So these are shareholder class actions based on alleged misstatements in publications made to the market. And the targets here in the US are the big listed BDCs or the asset managers themselves. So the likes of Blue Owl, BlackRock, KKR, Hercules Capital. And it's that last one I really wanted to focus on, the Hercules Capital claim, because there the complaint is very much focused on deal sourcing, due diligence, and underwriting. So the way that complaint works, it's quite simple, really. It just takes some statements from their quarterly reporting and press releases about their origination and due diligence processes. So things like the size and specialisms of their origination team, how the underwriting process works, the role of their legal team and the investment committee, and so on. And it then just seeks to rely on some public reporting, really based on one interview with a sort of whistleblowing former analyst to allege that all of those statements made to the market were false. Otherwise, so both in that claim and in the other claims we see, the focus is on statements around things like valuation, which I mentioned. So timeliness, methodology, reliance on third parties, reliance on models. Portfolio categorization, so for example, mischaracterizing investments to understate exposure to the software sector. Liquidity and redemption dynamics, so understating potential redemption pressures. We see that particularly in the complaints against Blue Owl that are out there. And also income quality, so disclosures around cash receipts as against payment in kind receipts. The third bucket, just to mention quickly, is really just one claim at the moment, which is a derivative claim brought by investors in the name of one of the Blue Owl BDCs against the main Blue Owl advisory entity. So that complaint is alleging breach of fiduciary duty and is mainly focused on complaints about the fee structure. So it's allegedly excessive, creates poor incentives, mainly because fees are based on gross assets and net investment income, with the latter including PICs, so not actually requiring cash receipts. There are then related complaints in that one about valuations being inflated. So, for example, where a particular name in the portfolio is marked at 90 cents, when there's observable pricing in the market for a more senior debt tranche at lower prices than 90, which, on the face of it looks a bit curious. So overall, I think these claims in the US are instructive as to what claims in England and indeed Europe might focus on, but there's no need to panic yet. And I say that for a few reasons. So this is why I said I wasn't being too doom and gloom, Olivia. They're at an early stage, these claims, and I think as an English lawyer looking in at US complaints from the outside, there are real questions, I think, around their merits. US complaint documents are often a good read, but they're not subject to the same rigor as claim documents in England. We also don't have the same listed BDC structures in England, which are vulnerable to securities claims. And then lastly, we don't really have a comparable class action regime outside of competition and antitrust claims. So generally, claimant firms and funders are going to need to book build, which is much more challenging, especially in retail when you have hundreds or more investors. It's not the US, so this is not really an answer to your question, I'm afraid, but I've mentioned MFS twice, so I just wanted to touch on it briefly before we move on. This is, of course, the collapsed bridging lender. I'm sure lots of people are familiar with it and probably know much more about it than I do. It had very substantial private debt and related bank debt, and there are, I think it's accepted, going to be very significant creditor losses. Just on the legal side, again, I think lots of people will know that Alex Partners were appointed as administrators earlier in the year. and they've got a worldwide freezing order against Paresh Raja, who's the majority owner and CEO. And that's an order restricting his assets up to the princely sum of £1.3 billion, which is the amount he's alleged to have misappropriated or caused the misappropriation of. And that's about half the total amount of 2.6 billion that's said to have been advanced to this company or its affiliates by external lenders. Alex filed particulars of claim against Mr. Raja last month in May. That's a public document, and anyone in this space, I think it's well worth having a flick through that. Again, it's early days and these are only allegations, but it struck me that there are some notable points in there around things like the controlled environment and the quality of reporting, corporate structures and complexity. So they had a huge number of SPVs and hundreds of bank accounts to run this company. Governance, and particularly the concentration of power in a single individual in the case of this company. And also, I think, reliance on third-party advisors. So it's a matter of public record that the FRC, the Financial Reporting Council, has opened investigations into accountants, auditors and firms who acted for MFS and connected companies.
Thank you. So apart from perhaps there being a degree of sensationalism in my introduction to you and also in how these claims are presented in the US, what are some of your kind of key takeaways, if we could kind of quickly summarise that for the audience based on the litigation that we're already seeing and then your experience of similar claims as well?
Yeah, sure. So at the risk of repeating myself a bit, I think disclosure and representation is going to be absolutely key. So any statements made in marketing or other materials, statements to wealth advisors, potential investors and so on about origination, due diligence, underwriting and so on, obviously need to be true, but also in a way that can be verified and demonstrated, potentially many years after the event. And the same is going to be true for other aspects of the fund, so fees, valuations, redemptions and so on. All of that means that the quality of documentation is going to be absolutely key. I think all of that also applies to advisors and intermediaries. So recommendations and advice as to suitability need to be properly documented. The second and final point I'd make is that the scale and type of litigation may depend on how the market in the UK develops. So a lot of the controversy and the disputes noise that I see in the market is around retail. I'm obviously a lawyer, I'm not an investment specialist, but there does seem to me to be a question mark over retail private credit from the stuff I read. And the question is whether retail investors' expectations as to liquidity are really compatible with private credit and whether that circle can be squared, as it were. There's also quite a lot of noise at the moment about the growth of private credit long-term asset funds in the UK, but from what I see, they mainly seem to be targeting pension schemes, some private wealth channel, but not really much retail at all. And we'll see whether that's going to change over the next 6 months or so. The point here again is that it seems to me that mis-selling risks are going to be higher with retail investors.
A very neat soundbite to end on there, thank you. So Jake, if we come to you now and possibly with a slightly different hat on. So Emily's talked about how the regulator is thinking about this and Dan's walked us through what happens when these deals do end up in court. But you spent years on the investment side and really doing the diligence on deals before you came to Themis. So you have sat in the seat that has to actually sort of run this process. So given everything that we've heard about where the regulatory and legal pressure is heading, what do you think that actually changes for how a credit fund runs its diligence today? And is this the way that most firms or the way that most firms are approaching this? Is that still fit for the market that we're operating in right now?
Thanks, Olivia, and thank you to Emily and Dan. That was very insightful. I think that a lot does need to change in the next few years about the way that private credit funds run diligence. Otherwise, you're going to find yourself sitting across the table from Dan or some of Emily's friends at the FCA, and that's definitely not where you want to be. I mean, taking a step back, most firms' diligence models were built for a different market than the one that we're in now. They were built for a bilateral point in time world. You do the work at origination, get comfortable, sign, and then move on. And that made sense when the borrower had a sort of single lender and the relationship was legible. That isn't really how things are structured anymore. A single borrower today draws on private credit funds, bank facilities, NAV lines, and warehouse structures, and often all at once. And no individual lender necessarily sees the whole picture, not the total leverage, and not whether the same collateral is sitting behind someone else's loan as well. So I think two things need to change. I think the first is the unit of analysis. You need to stop looking at only the counterparty in front of you and start looking at the sort of network around it, because that's where the risk actually lives now. The second is that diligence stops being something that you finish. Point in time work can only ever tell you the borrower looked fine on the day you signed. And the reason this matters, the reason it connects to what Emily and Dan are saying, is that the cost of getting it wrong now comes from both sides at once. The regulator is treating it as a systems and control question with individuals personally accountable, and litigation is following the losses, as Dan mentioned. So the response isn't more kind of forms and more signing forms at origination. It's actually a different shape of the process.
Okay, yeah. So if we're going to look forward, let's say we're sitting here in 2 years' time and a credit fund has got this right, what does that actually look like in that situation? Like, how does good appear? And what is it that they're doing differently from the firm that lent to MFS, for example, or any of the borrowers that we've seen fail with the warning signs that are ostensibly sitting in plain sight?
Sure. So I'm quite optimistic about this, because I don't think any of it's particularly technically hard. It's more a change in mindset more than capability. I think the first shift is that diligence becomes continuous rather than a one-off at origination. You map who owns and controls the borrower, who it's connected to, what its record shows, and then you keep watching, because the borrower that passed every check at signing is exactly the one whose behaviour deteriorates quietly between reporting cycles. This matters, I think, more in credit than people from the private equity world would assume. A private equity investor who finds a problem after the deal can change the management, replace the board, fix it. But a lender can't. You're limited to the rights in the loan document. And for the life of that loan, you're relying on the borrower telling you the truth in the quarterly report. And those rights are already there. The agreement carries undertakings on sanctions, financial crime, change of control, and they're live for the whole term. But whereas the financial covenants get recomputed every quarter because someone owns that, the integrity ones get checked once at signing and then nobody looks again. So continuous monitoring just makes the protections already in the contract mean something. The second shift, and I think this is more important, is the one that the work stops being a kind of one size fits all. Right now, most diligence treats every counterparty roughly the same, regardless of where the exposure sits. But the depth should follow the risk, and the riskier exposures get more scrutiny and more frequent refreshing and more human judgment, and the rest get proportionally less. Running it continuously across the whole book is what frees you to concentrate real human judgment on the cases that warrant it. And once it's continuous and weighted to the risk, it stops being a kind of box compliance ticks after the fact and becomes something that the deal team relies on before they commit. And while the loan is live, it moves from the compliance to the deal execution team. The other thing that changes is kind of what you're left holding. Today, the output is a kind of credit decision and a file that then gets closed. In 2 years, it's going to be a live, continuous, auditable record of who the borrower really is, who it's connected to, what was checked and when, where it mattered and who signed it off. And that's exactly what the investment committee wants, what the LP wants, what the insurer wants, and increasingly what the regulator wants whenever them asks the question, the only question that matters, which is, was the diligence adequate and can you prove it? Not just adequate, but like provably adequate. And it comes back to the kind of the MFS case, and MFS told its backers that it had issued £45 million of loans in a year. Its own filed accounts recorded under £200 of loans. So the gap here sat very much in the public record the whole time, but there was no one there actually looking to find that information. And so we kind of need to have a different approach to diligence, which is kind of this continuous monitoring rather than a kind of point in time solution.
Wise words indeed, Jake. So, okay, thank you to our panelists. We've kind of funneled through from the regulatory context to what can go wrong in some case studies, and then the practical steps of how firms can protect themselves. So if you have any questions on any of that, on anything that our panelists have said, please do feed them into the Q&A now. We've got sort of 5 or 10 minutes or so for questions if we need them. Emily, there is one for you around AI, which I thought there would be, which you kind of mentioned early on in your question. So you talked about some of the progress that's being made, some of the advancements that you're kind of seeing happen perhaps in the future of AI in relation to how it kind of changes financial crime compliance. So I wonder if you could give us some examples of that, maybe of the stuff that you're finding most exciting and kind of persuasive, and then maybe on the other side as well, maybe where firms should be cautious around this.
Yeah, sure. So I think there's actually, it sounds a bit geeky, but there's lots of excitement in this area, lots of excitement. So if you look at India, for example, so India had a grand meeting of multiple firms, multiple technology, multiple regulators, all together, basically locked in a room for a weekend. And they came up with a financial passport for India, which meant that those old, fundamental, what's your telephone bill, your whatever bill, that apply to the retailization for these funds, those things sort of disappeared almost overnight. And then you had this constant trusted record that said, yeah, we know who this person is. It meant that there was much more liquidity in the market, people could open accounts quicker, but it also meant that there's better trust in the market too. So that is an example of something or somewhere where technology really has progressed and moved things on. And then if I go back to what the FCA is doing now, so the FCA opened its first sandbox probably about 10 years ago, and now it's got multiple of them, multiple sandbox where people really are trying new things. Again, the AI bandwagon word, but with AI, using synthetic data in order to help understand and explore the ways that criminals are operating. Everybody's been through that, layering, washing, training program on understanding how criminals operate. Much more sophisticated than that now. So with quantum computing coming as well, it just means that the speed, the hyper-personalization, the ability to spot is going to be harder, and you need to keep on top of it. You absolutely need to keep on top of it. So lots of things happening. Again, if you want to understand more, talk to the regulator, get involved. You can go along to these sprints for the sandbox they have occasionally, or just read some of the speeches that are coming out now. I think Nikhil Rathi did a speech last week where he was really pushing that technology advancement. So lots going on.
Fascinating. So this question actually I think probably leads on quite nicely from that. And so Emily, I think probably one for you, and then Jake, if you have anything to add, do jump on after that. So as a PhD researcher examining illicit finance involving Russia, China and Iran, I'm interested in whether regulators are becoming more concerned with networks rather than individual entities. Should private credit firms be investing more in mapping corporate relationships and indirect connections, even where there are no sanctions or obvious adverse media?
Okay, so this is a question that really is touching the edge of what I can say. So, I mean, you've named some countries which suggest that you're looking at government action rather than James Bond style criminal networks, but you absolutely do get both. So there may be some government action, there may be also some criminal groups that are operating on a global presence. I think the important thing to note, and again, this is public because it has been in speeches, is that the FCA is working closer with other organisations than it ever has before. So whether it's HMRC or Companies House or any other organisation out there, it is sharing data, it is sharing information. And this is happening in the UK, and it's also happening globally. There are global operating agreements between countries. In fact, there's a worldwide one on AML that means that countries can share information to try and get on top of these things. So yes, it is happening. Yes, it is real.
Yeah, I think following on from that, I think going back to something I think Emily said right at the beginning is firms are obviously always in a sort of dilemma between where they allocate resources to kind of more growth or to kind of having more robust compliance, more robust infrastructure. I think where AI helps with the kind of when it comes to these networks is it actually brings the cost right down for private credit funds to be able to check these networks in a very cost-effective way using AI. And obviously to give a shameless plug, Themis can help them do that. But I think very much so that is the direction of travel. And I think private credit funds would be wise to be on the front foot on this rather than be kind of lagging behind.
I think this one might also be for you, Jake, if you're happy to follow on from that. So whilst the focus is on the due diligence around borrowers for the private credit firm, are there similar considerations in due diligence focused for investors, co-investors for the loans?
Yes, I mean, being absolutely, and I think Dan can speak to this as well, but very, very much so. I mean, there's pressure coming from all sides for GPs in the private credit world, and they need to be able to kind of have this continuous auditable report that they can show LPs, they can show borrowers, they can show regulators. And I think it's the same pressure is coming from all sides. And I think the product that you need to give each one of those stakeholders might be slightly different, but it's all it's mostly around the same sort of things. And again, AI helps the burden here. And I think going back to something that Emily said, it is great when it comes to reporting if you can configure any kind of AI model that you are using to then configure it with your own context, your own risk models, that you can then take that data and then create reports for LPs, for insurers, and so on and so forth.
Anything to add to that, Dan? Yeah.
Well, all I would add, I mean, Jake made some great points about ongoing monitoring in the context of looking at borrowers. And I think the same applies at the fund level as well when you talk about documentation. So, it's all very well having the most rigorously verified documentation in the world about, for example, your due diligence evaluation processes when you launch a fund. But if things evolve and you change your processes and you're still taking new money later on, then you need to make sure your documentation is updated so it's live and current and reflects the reality of what you're doing. Otherwise, you're going to get yourself into difficulties.
Amazing, thank you. So I think in the interest of time, we will probably wrap up now. We do have, as you can see on the screen, a free briefing note on our website that you can download from there that has some more on the kind of risks around private credit and also some of the notable case studies that we've kind of touched on here and lessons learned from them. We will also be releasing a series of blogs on this topic over the next couple of weeks, so do keep an eye on our website for those. And of course, if you did have a question that we didn't get to answered or you want to talk more to one of our team, then do get in touch with us. We've got this lovely QR code on screen here for you to book a meeting directly with Jake. I just want to say a really, really big thank you to our panelists for their time and expertise this morning and for really giving such kind of considered and informative answers. I really do appreciate it. I know I've certainly learned a lot, so I hope the audience have too. I'm sure I'm not the only one. And also a big thank you to our audience. Thank you very much for joining this webinar today, for your sort of good engagement and questions. And I know how busy you all are, so your time and attention are also very much appreciated. So with that, it's a goodbye from me and on behalf of us all at Themis. I really hope you have a lovely rest of your day. Goodbye.